Happy Constitution Day, September 17th. Um, Although you may not be watching this on Constitution Day, I'm recording this for Constitution Day, but for other reasons as well. Um, Kelo versus New London, or the city of New London, um, I think it's an interesting case. It's approaching 20 years old, but it's still precedent and still relevant to, I think, our lives today. And I think it's an intriguing story. So I decided that I would talk about this for Constitution Day. And it revolves around the issue of eminent domain, this legal concept that grants government the power to take individual private property or corporate private property uh, for a public use, right? Provided that the property owner is justly compensated and allowed due process, right? Allow their day in court if they feel that their liberties are being sort of trampled on, right? And so we'll talk about the Fifth Amendment as well. This principle is based on the idea that, sometimes government needs to acquire land or real estate to carry out projects that serve the greater good of the public, right? Such as a public university or roads or highways and parks and essential infrastructure. And so it is a very old concept, and case after case has granted or acknowledged the government's power to take our property as long as, again, through due process and we're justly compensated. This notion of being able to take our property as long as we have a due process procedure and we're justly compensated is part of the due process clause in the Fifth Amendment and the takings clause in the Fifth Amendment. The due process clause, right, is in yellow here at the near the end of the Fifth Amendment, and at the very end is the takings clause, right, right. No one should be deprived of life, liberty, or property without due process of law, the due process clause, nor shall private property be taken for public use without just compensation, the takings clause, right? And both of these, right, are relevant to this Kelo case. I like to talk about this case not only because it's very relevant to a very important part of our Constitution and Bill of Rights, the due process and takings clauses, right? But early in my academic career as a graduate student, I started to do research on how cities engage in local policymaking to make their cities better, to address crime, to create more jobs, to have better roads, to address blighted areas, right? Just to make the city better, right? And so Max Nyman, my mentor, and I have published a number of works back ages ago about what do cities do to make our cities better, and do they work, right? And so I was fascinated about this case in part because it's such an important topic, right? Our private property and the protection of our private property. But also I've always been interested in local politics, local and state politics, and economic development, right? And I think this is an interesting case in that eminent domain, no one is questioning that the government has the power of eminent domain. Well, maybe someone, but it's pretty clear throughout court cases that the government has the power of eminent domain. But in what cases, right, would it go beyond public use? And what is public use, right? There's a narrow notion that the taking of property will be used for a government purpose. Government will use that like it's a public university or it's a public highway. The government actually owns that land, right? And people around it can use it, right? It's owned by the government. That property is now owned and monitored by the government. Or is it broad enough to include the taking of property and giving it not to the government, but giving it to another private individual or private entity, if that private individual, that new private individual or private entity or corporation can do something better with it that generates more taxes, property taxes, sales taxes, or maybe creates new jobs, right? And I think another reason to talk about this case was that in the end, this was a controversial decision, and we can kind of note that in the 5-4 decision, that this was a split decision, right, of the U.S. Supreme Court. So the 9 justices that are experts in constitutional law, or supposedly experts in constitutional law, they were divided about the Fifth Amendment and its application to this particular case in New London, Connecticut. And I like to remind my students that although we get obsessed with Barack Obama or Donald Trump or Joe Biden or the next president and the federal government, and of course the federal government is extremely important. And the 3 branches of the federal government, and we'll be talking about the judicial branch here at the federal level, the U.S. Supreme Court, right? The federal government is clearly important, but typically your interactions on a day-to-day basis or year-to-year basis is going to be frequently with local and state government, right? Whether it's local law enforcement, or if you're being charged with a crime, it's highly likely it'll be a state crime, right? You'll go to state court. So really, I think what our cities and our states do and their policies and their laws affect us so greatly. We forget about that because we get so obsessed with what our current president's doing, right? And in fact, local governments and state governments can do things that greatly affect your life, perhaps even much more so than the federal government. And as Tip O'Neill once said, this saying goes back at least to the 1930s. But if you say all politics is local to a political scientist, I promise you what will pop up in their mind is a former Speaker of the House, Tip O'Neill. Right. So let's talk a little bit about the backstory of this case, right? Look at some of the facts. Kelo, right, brings this lawsuit along with some other families as well, property owners. Suzette Kelo, like many Americans, right, dreams of owning a home. And in 1997, she found an older home, 107 years old, with a cracked foundation, peeling paint, no yard or driveway, and located in not a blighted area, but a gritty neighborhood, as one professor, law professor noted, right? Near warehouses, near a junkyard, near a sewage treatment plant, right? Not the best neighborhood, but not the worst, right? And, but this home had a nice view of the river, and she made an offer. The seller wanted $59,000. She made an offer in 1997 of $53,000, and the seller agreed. And her stipulation was that, hey, you got to put a fresh coat of paint on it. And when she was asked what color, she chose the color pink, right? And so really a lot of people know this case as sort of the case of the little pink house in Connecticut. And here's a picture of that house, right? So Kelo lives in the city of New London, and she lives in the Fort Trumbull area that, this area, this neighborhood might not be the best. So the governor, along with other people, the governor envisioned a redevelopment project along New London's waterfront. The city of New London, especially this area, certain areas near the waterfront, had a growing crime problem and an unemployment rate that was twice the state average, right? And so the governor tapped an experienced lobbyist to head a project, and they formed a nonprofit corporation called the New London Development Corporation, the NLDC. And this urban redevelopment project, right, initially started as a 24-acre plan for some major company to come in, and if they needed some extra space and to build some facility. And they found Pfizer, right? who was in need of expanding because at that time they had sort of just developed a new drug, Viagra. And so sales were taking off and things were doing well. And to lure Pfizer to this area, the city provided the company with a 10-year tax abatement. Right? That plan grew from 24 acres that would include a major corporation to have land to develop a facility to 100 acres that would include some facilities that would help grow that area, help Pfizer expand, would serve some of the workers, right, and other surrounding communities with restaurants, hotels, upscale housing, etc. Right. And again, if this plan saw fruition, it might have been a great idea, right? Again, as I'll note later in the lecture, redevelopment projects have mixed history, right? Some good examples are Times Square in New York, which has been redeveloped. I know I used to live near Cleveland, Ohio. Jacobs Field and some other sort of redevelopment helped sort of redeveloped the downtown Cleveland area. But for every success, you can probably find a disaster that didn't work out as planned, right? But again, this was not a crazy plan, and it was nothing that was necessarily typically out of the norm, right? When developers and lawyers were looking at this, right? So poor Suzette Kelo buys this house, right? And less than a year after moving into this home, she finds out the city of New London wants to take her property and over 100 other properties in the Fort Trumbull neighborhood for this redevelopment plan to help reinvigorate the local economy. Many of the property owners in this area took the initial offers that were typically a bit over market value, fair market value. So most of the 100 plus properties, they were sold to this non-profit corporation. But 7 other families, right, which in total owned 15 properties, Suzette only owned 1 property, they decided that they didn't want to move, and they fought the city. Now, not all development projects need to use eminent domain. And in fact, right, as I just said, all but 7 of the property owners had said, yeah, we'll sell. The government offered me a fair price. It's probably going to get developed and there's going to be a lot of construction, so might as well get out of here, right, and buy something else, right? So for a lot of people, they took it. They might not have necessarily been happy about it, but they didn't want to fight City Hall, right? And so typically, if you look at the history of local development, governments can gain properties by simply buying them, right? And not using eminent domain. Basically bribing people. Get out of your house. We're going to give you this much money, right? Kelo was offered $68,000, right? She bought her house for $53,000. And a couple of weeks later, she was offered $78,000. Later, she was offered $123,000. The city knew that taking property using eminent domain, especially for a project that would give some of this property to a private developer, would be controversial. So they were hoping to just buy this property without using eminent domain to force someone else, right? Didn't work, right? Suzette Kelo did not want to move, right? Even when they're offering more than twice what she paid. And so Kelo, being threatened with eminent domain because she wasn't taking these offers, these generous offers, called up the mayor of New London, Lloyd Beachy, and he connected her to a community organizer, and they together created the Fort Trumbull Neighborhood Association to stop this project, right? And Kelo would be the president of this new association. Now, although the mayor was behind Kelo, and if you dig deep in the story, at one point, I think tied himself to a tree to stop the bulldozers, right? The rest of the city council, right, was not. And the city council, right, the mayor typically in many cities are a weak mayor, where they're often just one vote in a city council, right? The city council voted to give the NLDC the power of eminent domain on behalf of the city, right? And that was declared to be legal as well. Kelo contacted the Institute for Justice, a public interest organization that specialized in property rights and government abuse, and typically provides legal advocacy for free, right? This interest group, this special interest firm, right? And the Institute of Justice looked at the case, and they were very optimistic because they had won a similar case in New Jersey, a different state with a different state constitution, right? Different laws, but we're all protected by the Bill of Rights and the Fifth Amendment, right? The government in the New Jersey case wanted to take a widow's home so it could be given to an Atlantic City casino, right? The Trump Plaza, owned by Donald Trump, right? And the property would be used for a limousine waiting area. And so the lawyers for the Institute for Justice felt that there was a similar argument that to take a private property and give it to another private entity is not, it goes beyond the public use taking clause of the Fifth Amendment, right? And so with that success, they thought they could put up a good argument for Kelo. So we see, right, even before the taking of Suzette Kelo's property, Pfizer starts to build its anchor facility, right? The state provides $75 million in incentives, $8 million to the NLDC to buy up properties. And you see this groundbreaking ceremony here where the governor, he says, years from now, this will be a case study in how to revive a community. He will eat his words, right? And the facility was completed in 2001, right? And Pfizer has this new facility. And so things look to be going well. Right. The major anchor for this project has already been built. And now, hopefully, surrounding restaurants and hotels and infrastructure will now come. Right. Build it and they will come, the notion. And the city argued that this urban redevelopment plan, right, included lots of benefits to the public. Yes, Pfizer is going to benefit. And the private developer that's going to be given the land to build hotels and housing, new housing, upscale housing, and restaurants, they're going to benefit, but the whole community will benefit, right? Perhaps lower crime, more jobs, and more tax revenue, right? Because this property will be worth more, the city will get more tax revenue, and therefore they can provide more police and more buses or more transportation or more whatever, right? Yes, Pfizer will be a major beneficiary, but the city as a whole will be a winner. And therefore, the takings, right, met the public use requirement of the Fifth Amendment. Kelo and other property owners argued that the taking of a person's home so that another private individual or company or entity can profit is unfair, immoral, outrageous, and, more importantly, unconstitutional under the public use requirement of the Fifth Amendment, right? So, Kelo and the rest of the six families decide to fight, right? In December 2000, They file a lawsuit in a lower court, the New London Superior Trial Court, and the court sort of ruled in favor of sort of both the city and Kelo. They made the argument that the city can take this property and give it to a private entity, but for 11 of the 15 properties that were mapped out for demolition, the project plan didn't specify a specific use, right, for those homes. And since there's no specific plan, right, those properties should not be taken, right? And 11, one of those 11 was Kelo, right? So her house could have been saved by this lower court decision. But Kelo was not happy that her other families, other neighbors were going to lose some of their properties, and the city wasn't happy as well with this decision. So neither one was happy. Neither side was happy, and they appealed to the State Supreme Court of Connecticut. Right? Unfortunately for Kelo, right, 4 of the 7 justices decided to reverse the lower court's decision and would allow, right, all of the 15 properties to be bulldozed and taken, right? Kelo was devastated. She was saved at a lower court, theoretically, but that was overturned, right? But the Connecticut Supreme Court ruled that Kelo could stay in her home until the appeals process was complete, right? Kelo and the Institute of Justice appealed to the U.S. Supreme Court, right? The last court of last resorts, right? That's the final stop for an appeal. The media across the country, for the most part, was supportive of Kelo and very critical of the Connecticut Supreme Court ruling. I think because it got such national attention in this small little neighborhood that no one had heard of in most other states, it got picked up very shortly after the Supreme Court ruling. The U.S. Supreme Court doesn't hear many cases, only between 100 and 200 cases of the more than 7,000 cases that cross its path for people appealing lower court decisions. Sees very, very few, but it heard this case. One, I think because you saw 4 out of the 7 of the U.S. Supreme Court, the Connecticut Supreme Court. So you had a divided court in the State Supreme Court of Connecticut, but also I think the media attention. And again, I think this is a controversial issue. What is public use? And that definition could affect not just Fort Trumbull, not just Kelo, but homeowners across the country. So this was I think, an important case, and the U.S. Supreme Court, right, was aware of that. So Kelo's lawyers from the Institute for Justice had to answer some tough questions from the U.S. Supreme Court justices, right? Where do you draw the line, right? When is there not enough public benefit or public use, right? Does it have to be 100% public use, right? If there's one private entity that benefits, but most, for the most part, 99% of the benefit is public, where's the cutoff line, right? When would there be enough public use for Kelo or this public project to be constitutional, right? The courts, I think, were worried about, oh, well, Suzette Kelo, she's this really nice woman. She's a nurse. She just bought this house, and it's a cute little pink house. Oh, she's really sweet. This seems unfair. Let's rule in favor of her. The courts don't want to do that. They want a rule, right? They want a principle, a clear-cut principle that they can apply, whether you're applying it to, oh, sweet Suzette Kelo, or to some jerk, right, who just doesn't want to sell, is just being stubborn, right? Um, they don't want to just they don't want to rule on just how empathetic a client or a plaintiff is, right? I think that's a good point, right? I think these justices of the U.S. Supreme Court are aware of the controversy underlying the taking of someone's home and giving it to a private developer to build hotels, right, restaurants, which will be owned and profited by other private entities, right? The attorney for the city avoided the where to draw the line debate by arguing that it is constitutional to take property from anyone. Let's say Motel 6, right? I don't know if you've ever stayed in a Motel 6. I have. They're very modest, to be polite, right? But I know when I've traveled across the country, driven across the country, it's nice because you can literally park outside the front door of your room and then just bring your bags in, sleep there, use a shower, hop in, whatever. It's not a Ritz-Carlton, right? It's not a Hilton, right? So the city's attorney said, if you have a less affluent motel, you can seize that property and give it to a bigger corporate hotel chain if they would pay more property taxes or sales tax. More tax revenue is a public benefit, and therefore, boom, that addresses the takings clause of the Fifth Amendment, right? And someone had an interesting cartoon, right? Life, liberty, and the pursuit of tax revenue, right? And so tax revenue is a public good, and so we can go and take your house, right, and do that for the public good. Kind of rubs you the wrong way. Your gut reaction, I know when I first read this case, was like, this is a horrible decision, right? And it was divided 5-4. These Supreme Court justices, these experts of the Constitution, were divided. Justice John Paul Stevens, who, you know, in some cases, you've seen that he will vote to really sort of protect the underdog, right? I think some scholars had said because of his age and him sort of remembering Franklin Delano Roosevelt, and the Supreme Court stopping a lot of economic activities, economic policies, economic regulations of the New Deal, sort of remembered the Supreme Court getting in the way of economic development plans and programs of the federal New Deal under FDR, and was maybe a little bit hesitant to stop this economic plan, right? And so Justice Stevens, writing for the majority, writes that typically what you've seen in past decisions is that the notion of public purpose or public benefit or public use has typically been interpreted broadly in prior cases, right? And that courts that are not elected with lifetime tenure should give great respect to the judgment of state and local governments as to what is or is not a public purpose. Stevens said that promoting economic development is a traditional and long-term accepted function of government, and that under their interpretation, there is no principled way of distinguishing between economic development and other public purposes. And he makes the argument that states were free to pass laws, right, or amend their constitutions to raise the bar for what is considered public use. They could articulate what exactly public use is, but the Fifth Amendment does not provide that specific language. But that doesn't mean that states could pass laws or amend their state constitutions that could truly articulate, right, what public use is. Sandra Day O'Connor, writing for the minority, the dissenting opinion, argued that under the banner of economic development, all private property is vulnerable to be taken and transferred to another private owner, so long as that might be upgraded. That property could be upgraded in the process. So if your family, long time ago bought a house on the ocean of North Carolina, right? And it's been in your family for a long time, but Ritz-Carlton or Hyatt or whatever says, hey, that is some prime beachfront property. We could build a hotel on that and pay more taxes and make a lot more money. You're just like enjoying it by living there. You're just sitting there enjoying your beachfront property. We could create jobs and tax revenue. So let's ask the local government to take that property with its eminent domain power and give it to us because we'll make a lot more money off of that, right? That's a scary proposition, right? And Sandra Day O'Connor is articulating that scary hypothetical situation because of this case and this ruling. She argues that the fallout from this decision, right? I'm taking these words from a law professor, right? Who's paraphrasing Sandra Day O'Connor. The fallout from this decision will not be random. The beneficiaries will likely be those citizens with disproportionate influence and power in the political process, including large corporations and development firms. It's not going to be poor people that are going to benefit from this, right? As for the victims, the government now has license to transfer property from those with fewer resources to those with more. Good arguments. Good arguments. And my gut leans towards O'Connor's arguments rather than Stevens, right? But I think both are making valid arguments, right? The majority, right, the majority opinion articulated by Stevens, they cite several prior cases that I think are informative, right? In a unanimous decision in 1984, again, this is 2005, so it's a different court made up of some different judges, right? But in 1984, in a unanimous decision, the court held that the public use clause, right, in the takings clause, did not preclude Hawaii from taking property from landlords, leasers, they leased the property, landlords, of course, with just compensation, and giving that land to tenants, lessees, for the purpose of reducing the concentration of ownership of land in Hawaii. What the state realized was that the state owned 49% of all land in Hawaii, but the remaining 51%, right, 47%, right, of all the land was owned by 72 individuals. And that starts to create a monopoly, and that can be a major hindrance to economic development, right? And so a unanimous Supreme Court said, yeah, you can take properties from these really, really wealthy 72 individuals that own all this land in Hawaii, compensate them with fair market value, right? And give that property or sell that property, right, to other private individuals. So Kelo was not the first case where we're taking private property from a private entity and giving it to another private entity. And this was unanimous. So again, we might look at these 72 landowners and like, oh, these just rich people, they're just holding on to this land, they're stopping progress. We're going to rule against them because we don't like them because they're rich. We look at, oh, poor little Suzette Kelo, who bought, saved up and worked, multiple jobs as a nurse to save up money and bought this house for her kids. And less than a year, boom, we're forcing her out. We don't want the characteristics of the individual and how sympathetic we can be for them to determine whether something is constitutional or not, right? So again, you may disagree with the majority in this case. It was not a crazy decision, right? There was previous precedent. So Kelo loses. the decision was mostly greeted with outrage, right? As a month passed, many of the remaining holdouts took generous settlements. Homes began to be demolished. The neighborhood looked increasingly abandoned, right? And that's the problem with the holdouts in some cases, that you where you're living now is no longer the neighborhood that you once bought into, right? Um, with the Supreme Court case and her friends and neighbors gone, Kelo decided to move, right? But she was given $442,000 for her lot, right? So holding out, it was exhausting. Taking on government, going to the Superior Court, going to the state Supreme Court, going to U.S. Supreme Court, right? Years and years of not knowing what's going to happen to your home. It's not a fun case. And she lost her home, right? But she was justly compensated, I would argue, right? And, right, she had the idea of like, wouldn't it be cool if the house was relocated somewhere as a monument to this effort to fight City Hall, right? And to protect our liberties. And someone bought it, the physical house structure, and paid to take it apart and reassemble in downtown New London, in a different neighborhood, but still in the city of New London, to serve as a home for this local preservationists, and as a historic monument. And it's still there. It's still there. You could go to Connecticut, go to New London, and go to 36 Franklin Street. I think it's on corner of Franklin and Graham, I think, if I remember the story correctly, and go visit the little pink house, right? It's in a different location, but it is the very house that Suzette Kelo bought, which I think is a touching part of the story of this little pink house, right? In the end, the redevelopment plan fell apart. Pfizer did open that facility, right, in 2001, right? But not all the plans were built. The hotel, the restaurants, all the upscale housing never followed suit. Developers got the property but couldn't find financiers to fund that development, right? Sadly, Pfizer closed its facility in 2010, moving 1,400 jobs across the river to Groton, Connecticut, as a cost-cutting measure, which is a frequent thing that companies do. And of course, it might have been a coincidence, but it decided to relocate and close its facility just before its tax abatement, its tax-exempt status was to expire. So this idea that this redevelopment plan would create all these new properties that would create new and more and better tax revenue was a complete failure, because one, Pfizer didn't pay property taxes for those 10 years, and once you bulldoze, right, the homes and push out homeowners, they're not paying property tax, right? And so this was a disaster, and sort of just to make matters worse, as a salt in the wound, after the 2011 Hurricane Irene, that redevelopment area that had been basically bulldozed turned into a temporary dump for all the storm debris, right? Clearly not what the governor or what the city had planned. And that's the problem with redevelopment plans, right? Some are a success and some of them are failures, right? The area, as I could see today in 2023, still remains vacant, right? And therefore worse off than before. This redevelopment plan made things worse. But, right, a 2023 article said that another developer has an idea for new residential construction, and I think a hotel. And so there is a plan, and here's a drawing of that plan. So who knows? There may be hope for Fort Trumbull's neighborhood, and something might get built there, right? 20 years later. A side note that is really unrelated to Kelo is that the governor that was really one of the inspirations for this development plan, after he was governor, he was forced out because of impeachment proceedings, went to federal prison twice. Unrelated, but I just think it makes the story even more interesting. So, what did we learn, right? I think the evidence and the history of eminent domain suggests that governments typically would like to avoid using eminent domain, and they can by just offering above fair market value for the properties, and that can avoid court costs and legal costs and lawyers, right? And the story basically, when you ask the city council and the private development corporation, in the beginning they said eminent domain was not even on their radar. They had no plans of using it. But when 7 families refused to sell, they used it, right? The redevelopment plan, if it did work, could have been a good idea. It sounded like a good idea, right? Pfizer was thriving because of Viagra. You create a new tech sector or pharmaceutical sector. Maybe another like Silicon Valley, but with pharmaceuticals. It could have taken off, theoretically, right? And it probably would have if it was a success, provided lots of benefits. Tax revenue, infrastructure, new restaurants, could have reduced crime, created new jobs, right? But as I mentioned before, redevelopment plans across the nation have a mixed history. They are a gamble. They are a gamble. And they're a gamble using taxpayer money and possibly displacing people's lives, right? In principle, the city was trying to make the city better off. It wasn't like, how can we make Pfizer richer? It was like, hey, this is a blighted area. Let's try to make something out of it, right? Let's build something, right? But I think Justice Sandra Day O'Connor's point, right, that the fallout of the decision would not be random. The beneficiaries would be those citizens with powerful pockets, right, deep pockets, and the victims will likely be poor people, right? And history suggests that powerful interests will use every legal measure, every loophole, and even perhaps illegal measures to extract private benefits, right? Often at the expense of the public. And we have to be vigilant, right? We have to be vigilant. And I think this case shows that we can't always rely on the Bill of Rights. We sometimes have to fight for our rights. We can't just say, oh, well, the Fifth Amendment will protect us, right? The Bill of Rights and the Constitution is just a piece of paper, and it is not a perfect document. It is not. It cannot, in this relatively short document, relative to other constitutions around the world, that's relatively short, cannot protect all of our liberties in every context, right? We have a responsibility living in a democracy to know what our rights are, to fight for our rights, right? To know what our local and state officials are doing and to vote them out if they're doing things that we disapprove of, or to make sure we vote for people that do the things that we want them to do, right? And as Justice Stevens noted, right, Stevens didn't want the Supreme Court to be the referee for every eminent domain case, and whether that poor person or that poor widow or this evil rich owner, right, deserves their home to be demolished or not, right? And without a principle, Stevens made the argument that we should defer to elected officials, right, in this democracy. And if people don't like this decision, and many people did not, right, we can pass laws in our home states or amend our state constitution to address those freedoms that we care about, right? So Kelo lost her battle, But her fight and the media attention around it helped made her grassroots movement into I think you could make an argument, a national movement. This helped voters across the country to be inspired to lobby their state legislators for new laws or new amendments to their state constitutions to limit the eminent domain power of governments, right? And within 3 years of this case, 43 states, right, had done that, right? If we find a flaw or something we don't like, because we live in a democracy, you and I are able to fix it. Now, we weren't able to save Suzette's home, right? But because of her movement, the ability to take private property and give it to another private entity has been severely curtailed in most states across this nation, right? And we have Kelo willing to fight, right? Year after year after year, right? I'm glad she got that 443,000, but that was not a guarantee. She kept fighting and fighting and fighting. Because of that, many of us live in a state where our state constitution or the laws that we live under prevent our land, our property from being taken and given to Pfizer or given to a private developer or to be given to whoever, right? I hope you found this lecture interesting. Good luck and enjoy Constitution Day.